Hi, and welcome back to another exciting episode of Litigation Warrior. Okay, so we're going to call this one F.R.C.P, Coach. Okay, what's F.R.C.P? Federal Rules of Civil Procedure. You got it, F.R.C.P. These are the rules that apply when you get into federal court. Okay, these are not the rules in your state court. This is a federal court case, follows the federal rules of civil procedure. So what happens if you get involved in a litigation and the other party or the law firm is filing frivolous motions, frivolous pleadings, and they're doing things that are just wasting time and harassing, raising the cost of litigation? You must be saying to yourself, what can I do? There must be something I can do to stop them. This just doesn't seem right. But there is. So that's the exciting thing. That's what we're talking about in this episode of Litigation Warrior. Now, this is general legal information only and not legal advice or a substitute for legal advice. So let's get going. Okay, so this is Rule 11, F.R.C.P. When you're filing papers with the court, whether you're an individual or a law firm, you have a duty to present things, and you're making these, as it says here, representations to the court and sanctions. If you're not playing by the rules, you could be sanctioned. Sanction meaning attorney fees or some other non-financial remedy. But here's the general rule. I'm just going to see if we can get that going here. And I don't know why I'm always having troubles with this. But anyway, here we have it. Every pleading, motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. So the pleadings have to be signed by somebody. That probably sounds pretty obvious, but let's get down here. That signature means something. In Section B, that signature is a representation to the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or an unrepresented party, that's our improper parties, certifies, listen to that, certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry that's reasonable under the circumstances, you're making these certain sort of certifications. Okay, so bear this in mind. You're certifying to the court based on your knowledge or information and belief, things that you believe are likely to be true, after you perform a reasonable inquiry under the circumstances. So there is that due diligence obligation for you. But what you're warranting to the court is four things. Now let's take a look at this. Number one, by signing it, you're warranting that it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. So you're not filing things just to drag it on, raise costs, waste time. You're not accomplishing anything. You're just harassing. Okay, that's one ground. So in other words, if your opponent is doing that, then you can bring a Rule 11 motion for sanctions and seek attorney fees, monetary penalties, so forth and so on. So that's one of the things that's prohibited. Two, by certifying, you are representing to the court that the claims, defenses, and other legal contentions are warranted by the existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. So this is really important. This is a little hidden area that most people aren't aware of. For example, somebody may say, well, it's frivolous to file that motion. That's not the law. The Supreme Court has spoken. Remember, one time separate but equal used to be the law, if you recall. And if we didn't have these kinds of clauses, nobody could ever challenge a practice like that, because you would just say, well, it's the law can't be changed. No, an attorney or a party is able to present law to extend, modify, or reverse existing law or for establishing new law. But again, there's a good faith requirement that you're actually trying to do something that makes sense, betterment for society, that is not just some frivolous argument, okay? So that is the second thing you're certifying, okay? Number three, you're certifying that the factual contentions have evidentiary support. That means you have the evidence, you can prove what you're alleging, or if it's specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So I have the evidence, or I'm reasonably likely to get it, okay? And number 4, filing a pleading with a written signature certifies that the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or a lack of information. Okay, so those are your 4 things that you're certifying to the court every time a pleading is filed. Okay, and so if any one of those is not true, if another party can show with, I would say, a preponderance of the evidence, maybe clear and convincing evidence might be required, but to show these things that your client the opponent is making a mockery of the system, so to speak, you may be able to bring a Rule 11 motions for sanction. So here we have right here, if after notice and a reasonable opportunity to respond, the court determines that Rule 11b has been violated, the court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or was responsible for the violation. So anybody can find themselves in some hot water here if they're not careful with what they're doing. Okay? So let's take it down a little bit further here. Motion for sanctions. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that violates Rule 11b. Okay, so I just gave you the grounds, but you need to give the court the facts. You need to explain exactly what the issue is. Or as you see here in number 3, the court may do this on its own initiative. A judge could be sitting and looking through the papers and going, this is like the worst trash I've ever seen. I mean, who would file such? Why did you file this, counsel? And a court can seek what we say an order to show cause, issue an order to show cause why you shouldn't be sanctioned for filing such a paper. So a party against you can bring the motion, Rule 11. The court can do it. So there's different ways these can get before the court. Here's a little section. I'm not going to read it, but this is on sanctions and what it is, what it means, could be attorney fees. At any rate, that's a general overview of Rule 11. If you sat through this, you know more than the average bear does in regard to Rule 11 of the Federal Rules of Civil Procedure. This is Attorney Steve, general information only. And if you have more information, there's our website, attorneysteve.com. We thank you, as always, for watching our show. We'll have some more great videos coming up, so make sure to subscribe. And we'll be back. We'll see you again. Take care now.